The Waushara County Board of Adjustments to order. This meeting will begin with a public hearing. Anyone other than the applicant or the representative wishing to speak must register and submit the registration slip to the zoning administrator at this time. Following the hearing, we will conduct our monthly business meeting, at which time we will vote on the applications. You may stay and hear how the applications are decided, or you may leave following the hearing. The applicant and town board will be sent a copy of tonight's decisions. Any other person wishing to receive a copy of a decision can sign the sheet on the table at the front of the room. Those of you wishing immediate knowledge of the outcome of these proceedings may call the county zoning office tomorrow morning. The procedure we will follow for hearing each application tonight is, after each application is read, the applicant, their agent, or representative will be asked to present their application, followed by any questions or comments from the board. Then all correspondence will be read. Then others in favor will have a chance to speak. Anyone objecting will then have a chance to speak. I will then ask for a summary of the board's field observations and any staff comments. Finally, the applicant will be allowed a chance for a short rebuttal if they wish. Anyone wishing to speak should use the microphone at the podium, state their name, and direct their comments to the board. Because of the number of applications tonight, I'm asking all testimony be kept brief and to the point. The applicant will have 5 minutes to present information on their application, other than questions from the committee. Anyone else wishing to speak should limit their testimony to 3 minutes, and any rebuttal by the applicant should also be limited to 3 minutes. If you are testifying as a nearby landowner, please tell us where your property is located relative to the subject property. Tonight's hearings will be recorded, and the recordings will become part of the record. Comments that are based on hearsay or secondhand information, as well as slanderous or prejudicial remarks, will be ruled out of order. The committee has looked at all the properties, and the record will reflect these observations. Any person affected by the administrative decision of this board has 30 days from the filing of tonight's decision to file an appeal. Such appeals are heard by the Waushara County Circuit Court. Information on appeals is available from the Clerk of Court's office and qualified legal counsel. The county assumes no liability and makes no warranty as the legality of any construction commenced prior to the expiration of this 30-day period. I'll now introduce the board here tonight. George Peterman, Larry Tim, John Shirk, John Bentz. I'm Kevin Fitzgerald, our zoning administrator, Todd. We have 3 variances for tonight. The first one, Jerome and Deborah Fliss and John and Bonnie Knopp, co-owners, St. Francis, Wisconsin, have made an application for a variance after the fact in accordance with sections 58-451 sub C sub 4 of the Waushara County zoning and sections 18-31 and 18-103 of the Floods Code to construct a 4-foot by 28-foot one-story addition with an 8-foot by 22-foot covered porch, an 8-foot by 14-foot open deck, and to repitch the roof on an existing 38 by 32 non-conforming single-family dwelling, non-conforming due to ordinary high water mark setback, coming to within 38 feet of the ordinary high water mark of Twin Lake, and a 10 by 17 one-story addition. Cumulative improvements exceed 50% of the present equalized assessed value of the non-conforming dwelling, requiring compliance with flood protection code in the AG General Agricultural Zone within both the shoreline area and federally designated floodplain. Location: an approximately 0.71 acre parcel of land known as Lot 1 of Twin Lake Heights, Section 1, T20N, R11E, Town of Springwater, Twin Lake, N 7170 Akron Avenue is the address. I will now ask for who's ever going to be the spokesperson tonight or spokespersons come up and tell us a little bit about what's going on.
My My name is Bonnie Conup.
Pull the microphone down, talk into it, and then state your name, please.
My name is Bonnie Conup,
Okay?
and this is my sister Debbie Fliss. We are owners of the property. The property predates zoning regulations and has been used as a residential property. When it was constructed in the 1960s, it was in conformance with all applicable ordinances and laws. In 1977, a portion of the land, which encompasses the entire land from the home to the lake and approximately 50% of the existing home, was included in a floodplain. No homeowner was notified by any governmental body of such inclusion. 3 generations of owners of the property have continuously occupied and maintained the property since 1963. A porch had been constructed on the principal structure at the time of construction in the 1960s. The structure and porch met all applicable standards at that time. Over the last 50 years, as the structure, porch, owners changed and aged, maintenance, remodeling, and repairs occurred. Debbie and I noticed that when the adjustment board visited our property on Monday, the document with picture did not show renovations that our parents had done prior to taking ownership. It appeared to us that some of the records on file may be outdated. There were changes made over the years by our parents prior to those noted within this variance request. As rules and regulations changed, the principal structure and porch became legal, non-conforming structures. These types of structures are allowed to continue to exist per code. In addition, repairs, modifications, and/or replacement of any of the structures are allowed, as long as it is in compliance with subsection 58235B3, which also states the same. The current deck is approximately 36 feet from the water edge, as measured January 28th, 2020. Note that this measurement is not necessarily the ordinary high water mark, which is the elevation that is used for setback determinations. Regardless, the deck is outside of the 35 feet required per code for a deck. The former porch was 4 feet wider and therefore encroached upon the 35-foot requirement. The 4-foot addition to the structure offset the 4 feet of the former porch, maintaining the original footprint. The purpose of the reconstruction of the deck, besides normal wear and tear, was the fact that some of the owners became disabled. This necessitated that the inside porch needed to be larger to accommodate handicap accessibility. The deck needed to be adapted to allow for the use of a wheelchair and walker. The only access to the principal structure is from the water side of the structure. Due to the sloping nature of the land, the only way to construct a ramp for access was on the side of the principal structure on which it was constructed. If the deck had not been reconstructed to include a ramp, the property would have been rendered unusable by some of the owners. The construction of the deck actually brought the deck into compliance. The deck is not obstructing any view corridor, as it is parallel to the home and shoreline. The deck does not increase the degree of nonconformity, since it wraps around the front of the principal structure, facing the water, to the side of the principal structure, connecting 2 portions of the principal structure. While a building permit would have been obtained for all should have been obtained for all construction, the deck would have been granted a permit based upon it meeting all the standards. In regard to the 10 by 17 one-story addition, the original bedroom was 8 by 9 and was not handicap accessible. The remodel resulted in a bedroom of 10 by 10 and closet storage space. The bump out created a larger bedroom and closet, allowing the owner handicap access. All improvements addressed in this variance were made for owner handicap access. 2 owners passed in 2018. In our haste to accommodate them and adapt to the physical disabilities, we acted irresponsibly by not pursuing a permit. We apologize and regret our actions. Please note that our property is located directly adjacent to the public landing and is a highly visible area. Anyone can see what is happening from the public landing. We did not attempt to hide anything. The ADA changes and accompanying improvements cause no safety issues and have had a positive effect on the neighboring areas. Thank you.
Thank you. Okay, the committee, I have some questions for you. And then the committee will have some questions for you. When was the last survey done for the property?
This year, I don't know the exact date. but
This
it
year,
has been done.
2020?
Yes,
So you know where the lot lines and the ordinary high water mark are, correct?
yes, Trent was the one that did the survey from Watoma.
When you dealt with the construction, how did you deal with the erosion and stormwater runoff?
We didn't have any when we were constructing it.
You didn't have any construction?
We didn't have any runoff or storm water at the time of construction.
What type of foundation was it placed on the additions?
The concrete blocks,
What is the finished height of the highest point of the roof, do you know?
that I do not know. I believe it is on the drawing that was provided. I'd have to look at that, it's in my bag.
When we were there, they were working on a septic system. What's going on with that?
Currently, the holding tank has been capped. A sensor has been put in for us to allow us to know when it needs to be pumped. And we are having Trent mark out the tree line that Bill and the perk test person found to mark it out every 50 feet so they know what trees need to be taken down and what additional steps can or cannot be made.
The leach field would have to go up on the hill
Right.
from the corner.
Yeah.
So that's all gotta be.
That all has to be, determined.
Before you did the building, the additions, what other options did you consider?
There really weren't any other options based on entryways to the building.
Besides the disability hardships that you explained to us in your letter, what other unique property limitations would support your application?
The fact that we don't have any additional buildable ground right now. We didn't know we didn't have additional building ground before, but we have no additional building ground. So the footprint of the building is as wide as it's gonna get.
There are no other non-conforming structures on the property. You had a permit for the shed, correct?
Correct.
That's all I have.
You noted that you too did not get any permits for the work that you've done on the house. You also noted that your parents did a lot of work on the house. They obviously didn't get any permits either. Am I correct? You don't have any?
I don't know.
record?
They were the owners.
Okay,
We just noticed that the picture with the porch was not the porch that, I'm sorry, the picture with the porch that I was shown on Monday was not the porch that my parents
Right.
had on the building, which came out 4 feet more. So we thought there was something that was updated. And that porch I knew for 25, 30 years was on there.
okay,
So I don't know when they did what. We were younger than that.
sure.
Did it? In 2007, when you got the permit for the, excuse me, for the shed, you came in and got a permit, right? Could you tell us why you didn't come in and get a permit for this other work?
Because we were in haste to accommodate the people who were suffering from disabilities, and it was a mistake.
You never gave the zoning office a chance to work with you if you don't ask them, correct?
Correct.
Okay.
My husband was terminal, so I'm sorry, we did act in haste.
I don't have anything further.
Well, by not getting permits too, the zoning office was unable to notify the tax assessor. So you, for like 10 years now, you've been paying taxes on no improvements because you've gotten no permits.
10 years?
Well, so that's the last time it was appraised, was,
Last assessment was 2010.
right,
Oh.
last assessment.
But the construction was 2017, so it would be from.
Well, again, our assessors have not been able to be notified. So we can't send our assessors out because no permits have been purchased or gotten. So there's another reason why permits aren't just issued helter-skelter. There's reasons for them.
No, I agree.
And over a 3-year period, you couldn't come in and get the permits. You said that you did the work in 2017?
Right, if this isn't a construction.
Yeah.
I have one more question. When we were there on Monday, I asked what other work had been done inside. And I believe you told me that it was just for the addition of the bedroom, is that correct?
The inside,
Painting, yeah, over the years, we've done basic maintenance, yes, we've painted, we've,
there's,
Yeah.
New linoleum
on the floor.
on the floor. I think there's new carpeting in the one small bedroom.
When you added on 4 feet to the front of the house, to the lake,
Right,
there was a wall there. And then you added 4 feet on and put an outside wall on, and you took down a wall inside, correct?
Yes,
So there was other work done inside.
the wall was replaced, yes,
Okay,
sorry, I didn't understand.
okay.
the wall was replaced.
That's all I have.
So your husband
Talking
is,
to Mike John, please.
your husband is a builder, correct?
Correct.
Okay. What I'm really wrestling with is your husband's a builder, so he knows he has to have permits.
Right,
I
he
don't-
didn't, it was a family project, he was
Oh, I
not
understand
the
that.
lead.
I understand that.
Yep.
But if he was the lead, he knows he has to have permits.
Yeah, that was discussed,
Why in the world would he not get a permit?
because of the timing and how long a permit takes.
But he-
He wasn't the driver, unfortunately. It was an error, but he was not the driver.
We lost both the people that we built this for.
Oh, and I understand that.
We were
I
in
can't put
haste, we
mys-
wanted to do it
I can't
quickly.
put myself in your shoes. What bothers me more than anything else is you had a person that knows the system and disregarded it. That's what bothers me the most.
But because it's co-owned, we have to abide by everyone's wishes in a co-ownership.
But one knew.
Yeah,
One of those people knew what
understand.
should have been done.
We
And it
understand.
wasn't. And I haven't spent a lifetime on Board of Adjustments. I've never experienced such a flagrant violation as not getting a permit. So without getting a permit for building, that meant that the electrical or the plumbing contractors didn't have a permit.
The electrical had a permit
Where did they get their permit from?
through here. It was inspected and it was
Okay.
done under permit.
We don't, there's no record.
Michael's Electric did the permit, got the permit, and it was inspected. We do know that.
We didn't have any plumbing, I don't think we had any plumbing.
Mm-mm.
But electrical we did.
Yep,
So,
Not aware of it.
You don't have,
so Michael's may not have obtained a permit either, your subcontractor there.
he did because we had it inspected.
Well, that doesn't mean that there was a permit issued.
Well, if the inspector would have come out, wouldn't he have realized?
County inspector inspected it? Or was it somebody from Michael's that was back inspecting the work that their subs did?
No, it was the county. It was a separate
We can
inspector.
check on that, but
Yep, that was taken care of.
Do you know if your parents, when they made the alterations, they did that in haste also? So
No,
that's why they
I
didn't
don't know.
get permits either?
I don't know why they did what they did. Unfortunately, they're up there.
Okay. You don't know really why you're saying that in haste, you didn't get any permits because it was so important to get that stuff built without
And
permits.
permits, in my opinion, take a long time to assume, and his time was very limited.
You changed the whole roof line for the building. Was it an architectural engineer hired to draw the plans so that it would be according to state code?
No, my son has a architectural CAD software program, and he
Okay.
used that.
Okay, and who inspected his work?
He did it himself.
Okay. Nobody from the state came in and inspected it? The building
Correct.
inspector from Washington County didn't come and inspect the new roofing system, did they?
No, they did not.
Did they come and inspect the foundation that was poured?
No, they did not.
Okay.
That's all I have.
I have no more, Kevin.
Larry?
I just have one quick clarification, and it's just a matter of semantics in the statement that you read. At one point, you said, had you applied for the permits, they would have been approved.
For
And I
the
think-
deck, excuse me, for the
I
deck.
just, there's a process, and, if you would have said, just said, in our estimation, our opinion, in all likelihood, they would have been approved, but obviously, there's still a process to that, and there's still an approval that it does need to be officially, I guess, given to you, and making that leap in that statement just, was a bit, much, and just that,
Well, we had someone that has knowledge of zoning and building and is an engineer, where I live in the city of St. Francis, that
okay,
I asked for an opinion, and
Okay.
she did say, and she is our city engineer.
okay.
She said the deck would have been, I'm not talking about anything else.
Yep.
I'm just talking about the deck.
All right.
Okay, I think we don't have any more questions at this time. Just have a seat, and then we got some other stuff we'll do, and you'll get a rebuttal after we're done here, okay?
Anybody want copies of what I read?
Yeah.
Correspondence.
Okay. I apologize here. I have the first letter I'm going to read is from the Department of Natural Resources. I apologize, rather lengthy. However, it does refer to two requests that we have before us tonight. So I'll read just the information that's relative to the Fliss-Canop property. It's dated June 12th, 2020. Subject variance request for Egan property and the Fliss-Canop property, Waushara County. Dear board members, I am writing to you to provide the Wisconsin Department of Natural Resources, in parentheses, the department, comments regarding the Egan property variance request and the Fliss-Canop property variance request that are to be heard before the Waushara County Board of Adjustments, in parentheses, board, on June 18th, 2020. I appreciate that you all provided us with the materials for this request. I am providing these comments to you in response to State Statute 59.692, subparagraph 4, subparagraph B, as required by law, in place of making an appearance at the public hearing in person. Please have these comments delivered and read before the board and made part of the official minutes of the hearing, including how the board has taken them into their consideration. As the board reviews these variance requests, please keep in mind that the applicant has the burden of proving that their application meets all of the statutory requirements for the granting of a variance for each variance request. That is, the applicant must prove that they will suffer unnecessary hardship if the provisions in the county's shoreland zoning ordinance are literally enforced. The Wisconsin Supreme Court has made it clear that proof of unnecessary hardship by itself does not entitle an applicant to a variance. It may be possible that the applicant will provide additional evidence at the hearing, which may change the conclusions listed below. All of the statutory variance criteria must be satisfied in order to grant a variance. They are: Fliss-Canop property, unique physical limitations. The applicant must demonstrate that unique physical limitations, and in parentheses, wetlands, steep slopes, streams, rock outcroppings, or special conditions of the property exist that prevent compliance with ordinance regulations. The physical limitations must be unique to the property in question and not generally shared by other properties in the area. When determining if compliance is prevented, the whole parcel must be considered. The shape of the lot, the size of the lot, and the presence of wetlands should be compared with other lots on the water body in determining whether minimal relief is warranted. The encroachment of high surface water levels or wetlands are not unique to this lot and are affecting many property owners given the current natural conditions the county and the state is facing. No harm to public interests. The applicant must demonstrate that variance will not result in harm or be contrary to public interests. The board must consider the impacts of the proposed project as well as the cumulative impacts of similar projects on the interests of the neighbors, the community, and the general public. These interests are listed in the purpose statement of the ordinance and, for shoreland zoning, include protection of public health, safety, and welfare, maintenance of clean water, protection of fish and wildlife habitat, and preservation of natural scenic beauty. Additional impervious surfaces within 75-foot setback area can significantly degrade lakes unless there are means to mitigate the added runoff. Cumulative impacts to this shoreline should also be considered. Unnecessary hardship. The applicant must demonstrate that if the variance is not granted, an unnecessary hardship exists. The applicant may not claim unnecessary hardship because of conditions which are self-imposed or created by a prior owner. For example, building a home in compliance and then subsequently constructing a deck without a permit, or due to personal preference. Courts also determine that economic or financial hardship does not justify a variance. When determining whether unnecessary hardship exists, the board must consider the property rather than just a portion of the parcel. The department concurs with the findings and conclusions of the zoning staff report in recommending a denial for the variances requested for the various structures. It is the responsibility of the board to assure that the statutory standards for the granting of variances are met. While it may be hard at times to follow these standards, the standards help to ensure protection of the public interest, including the preservation of water quality and fish and wildlife habitat along lakes and rivers. Wisconsin's navigable waterways are held in trust for all people to enjoy. The shoreland setback is important to protect the water quality, natural scenic beauty, and the fish and wildlife habitat of Wisconsin's waterways. The department appreciates your commitment to the county's water resources and protection of public interest for future generations. We trust that you will make the appropriate decision regarding this variance request. Please note that these comments are in regard to shoreland zoning only and do not reflect applicable erosion control, waterway permitting, floodplain zoning, or other department regulations. Please contact me if you have any questions regarding these recommendations at 920-303-5440. Sincerely, Dale Rasbeck, Shoreland Specialist. I also have 2 letters I'd like to read into the record. The first is dated June 9th of 2020. It says, "To whom it may concern, I am writing to say I have no issues with the variance that was made by Jeremy and Deborah Fliss and John and Bonnie Knapp at N7170 Akron Avenue in Springwater, Wisconsin. Thank you, Barbara List." And the second is an email that was sent on June 9th to Cindy Rettler from Karen Karbowski. And it states, "Hi, Cynthia. Per our conversation, this email serves as affirmation for the parties mentioned in the above hearing to obtain a variance. We have no objection whatsoever for Jeremy and Deborah Fliss and John and Bonnie Knapp, co-owners, St. Francis, Wisconsin, to apply for or obtain a variance. Thank you, David and Karen Karbowski." And that's all I have for correspondence.
We have anybody registered to speak?
We have nobody registered to speak in favor, against, or even informational.
Okay. Staff comments.
Okay. Due to the, based upon the sequence of the events and the varying jurisdictional requirements, I am going to read the staff report verbatim for the benefit of the public and for the record. The applicants, Jeremy and Deborah Fliss and John and Bonnie Knapp, are requesting a variance after the fact to construct a 4x28 one-story addition with an 8x22-foot covered porch and an 8x14 open deck, and to repitch the roof of an existing 28x32 non-conforming single-family dwelling, non-conforming due to ordinary high water mark setback, coming to within 38 feet of the ordinary high water mark of Twin Lake. The average is 60-foot setback required, and a variance to construct a 10-foot by 17-foot one-story addition, all of the cumulative improvements exceeding 50% of the equalized assessed value of the non-conforming dwelling, requiring compliance with flood protection code in the AG General Agricultural Zone within both the shoreland area and federally designated floodplain. Now, the county maintains very little information on the property outside of an on-site that was performed in 2007 for a land use permit to rebuild an existing 12-foot by 16-foot shed located north and east of the principal structure. The home and sanitary system predate county zoning and, as stated above, are considered non-conforming due to shoreline setback limitations and current floodplain designations. The county zoning office first became aware of the issues in this report when, on or around April 15th, 2020, we were notified by the Department of Natural Resources of apparent unauthorized pumping of a wetland into a lake and filling of both a mapped wetland and federally designated floodplain. I'm going to break from the staff report just for a second because I would like to read also. I have had some conversations prior to this year with Mr. Conup on the property. In September 16th of 2019, I received a call from Everett Eckstein, who's a board member here at the county, regarding flooding at the Fliss-Canop property in Springwater. He had reached out to me to see if I could talk to them about what can possibly be done to protect their home. On the next day, on September 17th, I contacted John Conup, and we talked about the flooding situation, the fact that the water was rising in the adjacent wetlands. He was wondering about fill, and at that time, I informed him of the shoreline and floodplain codes, and it clearly explained to him that fill cannot go closer than 35 feet to the ordinary high water mark or go into or beyond the limits of the floodplain. On April 15th of this year and April 16th of this year, I contacted John again regarding the complaint that I had received from the DNR, and we talked about some photos that the DNR had forwarded that there were pumping water from the wetland onto adjacent land and into the lake, plus they brought in fill within the floodplain. John informed me that 100 yards of fill was coming in that day. I strongly advised him against filling beyond the north wall of the home, which is floodplain limits. John told me he's going to do what he feels he needs to do and that he will consult with his attorney. I told him to hold off until after 4/24 so that we can perform an on-site, review the situation, and hopefully assist. If fill goes into the floodplain prior to this, they will be required to remove any and all fill. On April 21st, I received some photos from Mr. Conup that work was performed against our direction, and the fill was quite significant, both on the side of the west side of the house and also towards the rear or the wetlands. Now, staff visited the property on April 29th, 2020, and while it did not appear that the applicants filled in any mapped wetlands, which are situated north and west of the residence, staff did note unauthorized fill within a small portion of the floodplain located along the west side of the home. It should be noted that the entire structure sits within a mapped floodplain as delineated on both the flood insurance rate maps and the county floodplain maps. And if you could refer to Exhibit 1, which clearly shows the mapping. Given the fact that the area of fill was minimal and staff was able to halt the applicants from completely filling in said floodplain, we consulted with the DNR and informed the applicants to cease bringing in any more. It was determined after my consultation with the DNR that we would allow what was brought into the property, which was approximately 630 square feet, that we would allow it to remain as is as protective measures of the structure. And if you refer to Exhibit 2, that was my on-site notes, which show that it depicts the 630 approximate square feet on the west side of the house. Upon observation of the property and residence, it was noted that considerably relatively new construction, siding, windows, doors, porch, decks, and addition to the rear of the home had occurred. After research of the county records, it was noted that no permits of any kind have been pulled outside of the land use permit for a shed located near the home. Based upon further research and receipt and review of assessment records and photos from 2010, that's the last known assessment, the former home is essentially unrecognizable. The previous home was approximately 28 by 28 with a 10 by 10 bump out, and that's depicted in Exhibits 3 and 4, and maintained an ordinary high water mark setback of approximately 50 feet based upon an old on-site from 2007, which was prepared by Terry Pockstadt, my predecessor, and that is depicted on Exhibit 5. It should be noted on Exhibit 5 that at that time there was talk about a remodel or a new home, and at that time there was talk about the need for variances. Obviously, none of that has occurred. The applicants have since constructed an approximate 4 by 28 one-story addition onto the south side of the home, an approximate 8 by 22 covered porch, as well as an approximate 8 by 14 open deck onto the lakefront side of the home. And those are depicted in Exhibits 6 through 10. As a result of the additions, the home now protrudes further out into the required ordinary high watermark setback and further into the floodplain and maintains a setback now of only 38 feet. And that's once again depicted on Exhibit 2, which was my on-site. The applicants have also increased the size of the bump out at the northeast corner of the home from 10 by 10 to now 10 by 18. That's depicted in Exhibits 4 and 6. While we are not able to view the work done within the residence, we were able to pull up images posted on the applicant's Facebook page from 2017. As evidenced by said photo, it appears that almost the entire residence was gutted and/or remodeled. Those are depicted in Exhibits 11 through 14. All of the aforementioned improvements were done without permits and/or any required building permits or inspections. Using the most recent assessed valuation for improvements on record, which is the last assessment of 2010, prior to construction of improvements $48,800, the applicants would have been permitted to improve the home an additional 50% or only $24,400. Or they have the option of bringing the entire structure into compliance with Section 1831 of the county flood codes. Said improvements, as depicted in those exhibits, far exceeds those maximums and do not meet current county and federal floodproofing requirements. The board visited the property at the recent on-site on Monday, June 15th, 2020, and were generally concerned over the fact that the applicants failed to contact the county to investigate constructive options and acquire the required building permits prior to putting themselves and the county in this position that we find ourselves. This was especially confusing since the applicants contacted the county in 2007 to have an on-site for a shed and pull all the required permits. The board could not recount similar variance requests or approvals in recent year. These requests would undoubtedly establish a very dangerous precedent and would increase runoff and make a bad situation worse. Now, variances seek a relaxation of a dimensional standard in the code. The decision to grant a variance must be supported by practical justification, which include, number one, that the code is unnecessarily burdensome and the landowner is not able to enact a permitted use without a relaxation of the dimensional standard. Number two, there are unique limitations on the property that prevent the landowner from meeting the required dimensional standard. And number three, if the variance is granted, no harm will be done to the public interest or the zoning code. It is the applicant's responsibility to present the case and provide the burden of proof as to why the variance should be granted. The personal situation of the applicant, financial hardship, convenience, a growing family, or nearby violations cannot be considered as valid reasons to grant a variance. The applicants have supplied responses as to meeting standards to justify requested variance. While there's no doubt this property is severely impacted by the effects of rising groundwater, floodplains, and wetlands, there is no justification for building closer to or within said impediments, when the simple and proper application of permits would have identified limitations well before irreparable damage was done to the state's waters and shorelines. It should be pointed out that both the shoreland codes and floodplain regulations do allow for expansions of non-conforming structures, but within certain limitations and subject to specific guidelines. A simple phone call and/or the application for permits would have identified the restrictions and limitations. The applicant also states that if the variance is granted, there would be no adverse effect on adjacent properties and will not affect fish, wildlife, nor maintenance of clean water. We would argue just the opposite. It is proven fact that the closer the home is to the water, the greater the impact, as there is no area for water runoff to filter impurities and less area for wildlife habitat. In addition, without proper floodproofing, there's greater financial burden upon everyone should damage occur to flooding because of rising insurance costs. Staff has reviewed these requests and raised serious concern over the very dangerous precedent that would be established over the extent and content of the variances being sought, particularly with regard to the setback from the ordinary high water mark and impact upon federally designated floodplains. The county has yet to approve similar after-the-fact variances to this extent. Despite the monetary value associated with not only the improvements made to the home to date and the potential costs associated with compliance, Blatant disregard for county, state, and federal standards and ignorance of the law is not justification for relief of adopted standards designed to improve the health, safety, and welfare of the general public. As to the variance request pertaining to the cumulative improvements exceeding 50%, there are things that the applicants can do and/or verify to satisfy the requirements without need of a variance. It has always been the directive of FEMA, DNR, and the county to strictly regulate, prohibit, and discourage development within federally regulated floodplains. While the board will be reviewing these requests and formulating a formal decision later in the evening, staff is recommending denial of the variance after the fact to construct the 4x28 one-story addition with the 8x22 covered porch, the 8x14 open deck, and to repitch the roof of an existing 28x32 non-conforming single-family dwelling, coming to within 38 feet of the ordinary high water mark of Twin Lake, and to construct a 10x17 one-story addition with the cumulative improvements exceeding 50% of the present equalized assessed value of the non-conforming dwelling, requiring compliance with flood protection code, subject to the denial reasons and conditions listed below. I would like to point out, just for note, the two denial conditions is number one, we're recommending that within 6 months, the applicant shall remove those improvements and/or building additions, porches, and decks extending beyond the original south elevation out into the ordinary high water mark and revise the design of the home to adhere to all other setbacks. Number two, within 6 months, the applicant shall permanently change the entire structure to a conforming structure in compliance with section 1831 and subsection 18103.1 of the county flood code, county flood code. And with that, that's all I have.
Okay. Ladies, rebuttal.
We did not fill the floodplain. Scott from the DNR is coming out tomorrow. He will confirm that. We did not fill in the floodplain, in the wetlands. We did not spend $24,000 on the remodel.
If you're,
And
if you're,
we had, excuse me,
okay,
and we communicated back in June with Todd. We communicated with Everett for years about all of the way they were plowing the snow and upheaving the public landing into our land and raising our shores. We've done this since 2009. Nothing is ever done. I have emails, I have letters. We've talked to people at this administrative building, and we get no help. So, that's all I'm saying.
We already apologized for a grave mistake, but some of the things that were discussed now were inaccurate. I know, we were told even by the DNR, we did not affect the thing. I also know that you can.
you didn't fill in the wetlands.
We did not
To
fill
our
in.
estimation. But Scott Kenke, just to let you know from the DNR, he's a wetland specialist. He's coming out to delineate the existing mapped wetlands that's out there.
Right.
He's not a floodplain specialist and won't be doing a floodplain evaluation.
Right.
Just for the record.
And I know there's different types of floodplain, and the floodplain that runs through part of our property is not the same as the whole floodplain, because I got those maps, and they were given to me. And I did talk to some specialists. So we will go farther on this then, if that's it, because that is not true. That is not true about that, that we can't construct on part of the property. So, and we did not go any farther. The setback, the I don't even know what you call it anymore, is exactly the same as the original, the footprint. We did not go farther towards the shore. We have been there, the first people on that lake. We have taken care of the public landing. We have picked up trash. We have cleaned up after people. If you ask anybody, we are the best caretakers of Twin Lake that there are. I have been there since I'm 6 years old. So to insinuate that we would do anything to harm the lake, to harm the fish. We love that property, and that's why we were taking care of it. This was a grave mistake. I acknowledge that totally about getting the permit, but some of the other things are just kind of, I just think that it's uncalled for. And as a board, I understand you have to look at the rules and regulations. You also have to look at reality and life. And I serve on boards, and I know that. And there is more to this than that. So, I mean, I guess I'm just, yours was so far in advance. And a non-conforming structure to conforming, the inside, if you look, is still, basically,
inside.
there's a propane furnace in the middle that my parents, I mean, it's there. We didn't change a whole lot of that. So we changed some basic things that were needed for someone with a wheelchair, someone with a walker, my husband with stage 4 cancer, and I guess I'm done too.
And we had 60 feet when we built. This is a 1% chance of flood.
Ma'am, the 60 feet you're referring to, it was to the physical water line. There's a thing called the ordinary high water
Yes,
mark.
I know.
Okay.
It's the thing that the county plows over every time they plow us in with the
The
snow.
county doesn't plow your road.
Well, the spring water, whoever does it, because we live on one side and they live on the other.
Well, back
So
up.
whoever's doing
Ma'am,
it,
they-
I have a
that-
picture
they
from
pl-
this April that they plowed it over.
It's fine, it's not us.
Okay.
It's-
I'm just telling you.
Okay, it's fine.
You can tell us things. You asked for my rebuttal. This is my rebuttal.
Okay.
And
And
it's
for-
on-
I don't think the plowing came up in Todd's statement.
No, it didn't because
So-
they so told us it didn't have any bearing. But it's continually raised the sides of our land because they constantly plow us in.
All right, thank you. Anything else?
Well, a simple phone call, or the application for the permits just would have identified all the restrictions and limitations which you ignored. So you state that the variance, so granted, it would have no adverse effect on neighboring properties, but in fact it would. Any home closer to the water is greater the impact on water runoff, wildlife habitat, and so. Ma'am. Okay, that's fine, that's fine.
Larry's got something. Larry, speak into the mic, please.
I'd just like to correct some.
No, yep, there you go.
I'd just like to correct some wording. The statement was made that this property wasn't assessed since 2010, and that's not really correct because assessments are done every year. And the wording should be that the assessment hasn't been adjusted since 2010.
Okay,
Next.
that'll conclude this one for now. We'll take our second one, second variance. Scott Egan, Watoma, Wisconsin. Todd Szerzinski, landowner, has made an application for a variance in accordance with sections 58-826 and 58-542 sub 4 of the Washera County zoning code to construct a 34 by 34 two-story single-family dwelling coming to within 50 feet of the ordinary high water mark of Mount Morris Lake, average 53.5 inches setback required, and to within 36 feet of the center line of State Road 152, average 46-foot setback required, in the RS-20 residential single-family zone within the shoreline area required. In the RS-20 residential single-family zone within the shoreline area, I read it again, a parcel of land known as Lot 17 of the Village of Mount Morris Assessor Plat, Section 16, T19N, R11E, Town of Mount Morris Lake, the address N3711, State Road 152. Will the applicant or representative please step forward?
Hello, thank you for having me. Can we hear me?
Thanks for being here.
I'm Scott Egan. I represent CNS Holding. that's basically my sister and myself that look at doing improvements to property in the area. I believe you all have a copy of the diagram.
We do.
And really what I was gonna look at telling everyone today, I've had multiple meetings with Amy and pretty much everybody in zoning. We've worked on this pretty hard to try and put something together that we can get a property of value to fit on this lot. You guys were all out there and looked at it. Because of the angle that the lake frontage holds, it doesn't really give us a whole lot of opportunity to put any type of property on it. If we looked at meeting the setbacks that are required from the lake, from the side yard, and from the road, it'd honestly probably be able to put maybe a 20 by 20 garage on the property, something very small. So everybody put their minds together, and we came up with roughly a 34 by 34 two-story dwelling. And my intentions would be to tear down the current home that is almost on the roadway. It's in the road right-of-way. I believe it's 23 feet from the center line. I would like to push the new home back to 36 foot. That gets it out of the road right-of-way, which is fairly important today. And by doing that, potentially, I don't know yet, we may be 1 to 2 feet, maybe 3 feet on the corner of the house in the high water. It's a 53.5 setback. I might be 2 to 3 foot on the one corner of the house in that area. And that's, again, because we're moving the house back off of the road. My intention as well is to take the 30 by 16 shed that's currently on the lake, and I'm assuming we all saw that. The corner of the lake, it's actually in the lake. So, yeah, it's,
It is.
a lot of people that have looked at it want to keep that. A lot of people that look at it think it's beautiful. We should remodel that and make that a lake house, which I've told them that can't happen. But that would come down, the current home would come down. The new home that I'm proposing actually takes up less square footage on the property itself. Again, we're going to maintain proper setback from side yard. I'm going to improve the setback from the roadway, and again, I'd only be probably maybe 2 to 3 feet on the one corner into the high water average. I might not even be there depending on how things lay out with the survey. I'm not the current owner of the property that Mr. Szynski is, so my intention and what I've done as we bought, we didn't buy, I built a home out on Silver Lake approximately 1.5 years, 2 years ago. And how I handle this is we'll go out with a surveyor, and the surveyor will actually mark our corners of the property. It's easy because it's a square. And to make sure that we're within what we're talking about here, after we dig the foundation, if I can get a foundation at all in, my intention would be to put a 2 to 3 foot crawl space in. If I can't get that and I have to do a slab just because of the high water, I don't know, everything's high right now. Before we do that, I have the surveyor come back out and I pin the corners. So then we know that we're going to be dead on the lines when we put our property in.
Okay, I got some questions. There'll be road setback questions and some water setback questions.
Sure.
First one is recent survey. Do you know how old that is out there?
It's the plat that you talked about. I think it was done in the 50s or 60s.
We know where the road right-of-way is, right?
Yes, we went out, we actually had, I think there's been 3 people from zoning have been out there and measured it, maybe 4.
Have you talked to the town of Mount Morris about it?
I have not.
Okay. You've spoken to zoning about it?
Correct.
State Highway Department?
No. We wouldn't be changing anything with the current driveway. The
Okay.
driveway would maintain exactly where it's at,
Okay.
where we would put the house.
Erosion and stormwater runoff, what are you gonna do with that?
Yep, that's something that I'm a licensed builder. When I pulled a building permit, again, with the county, we talk to land, and typically what's suggested and we do is we'll do a silt fence that'll encompass the entire property.
Foundation you already told us about. And when we were there, one of our notes said that you're gonna be, maybe have to build part of the house into the side of that hill there?
Yes,
So regarding that, I'm asking about the existing grade and about the first floor elevation.
sure. And the reason, did you guys get a picture of?
We did.
Okay.
Yes.
So by looking at this, when you're out at the visit, you notice you have to walk up 4 or 5 steps to get into the first floor.
Right.
Okay? My intention then, in order to get a drive-in garage to the property, otherwise there's no place to put a garage on the property, is to drop the house level with where we drive in, to be able to drive right into the garage. Okay? And then by doing that, it would have grade up on each side here and up on the back, roughly 3 to 4 foot, whatever it would take to get to that level to drop it.
So you'd have a crawl space then behind the garage, yeah, okay, but not under the garage, but to,
Correct, not under the garage.
Not under the garage.
Crawl space would only be under this portion, and only be able to put, furnace and water,
Sure.
things like that.
Is the garage in the right place on that
It is not.
diagram?
yeah.
And you're gonna have a side load, it's gonna be a side load more or less?
Correct.
Yep.
Yep. So this would be flipped. My intention is to have the garage towards the tavern.
Back toward the road.
Right, back towards the road, and then have the house and the view and everything for the people towards the.
Are you gonna come in from the highway in the driveway and then turn into the garage, or is the garage door face the highway?
The house would sit, just like the house sits right now.
Okay,
The house would sit just like it sits like this with the garage, so you would actually come in off of the road and into the drive, or into the garage, and then it would leave that existing area for a turnaround to be able to
Yep.
turn back
Okay.
and drive back up.
We kinda
okay.
guessed that.
Yeah,
Not knowing.
I mean, really, if you guys looked at it, there is like pretty much one house and one way you can put it on the property.
We had your picture out there and we were moving it all around trying to figure out which way we were going with this house. What's the finish height gonna be on a building?
Under the max, which I believe is 37.
35.
35?
Yep.
Besides the house, any other improvements besides taking down the boathouse?
None, everything will be level. My intention is to level everything, and have, the other, issue is there's a lot of invasive trees, out there, cause it hasn't been taken care of forever. Yeah, there's a ton of
New septic system going in?
new septic. I had Kirschner's out there already.
You're gonna have room for parking, correct? You already said that. You're gonna be able to turn around, you said that. Have you considered any other options?
I've gone through many homes with Amy, yes, this is not my first. We've gone through a lot,
Okay.
to try to make this fit, on this property.
You know what permits you'll need, right?
I pull them all the time.
When would you start building, if granted?
That's a good question. I'm fairly busy at this point. If granted, the proposal is to level everything within the next month and a half, have everything leveled off. Try to get some grass to grow back, offer this plan to individuals, and then potentially build yet this fall.
Okay, now we get some water setbacks here, so, questions. So Amy flagged the ordinary high water mark. Did you see that out there? Okay. All other setbacks gonna be met?
Yes, except for obviously for the road
Okay.
setback, we're gonna,
But your side lot line, you're good there.
yes.
What are the hardships and unique property limitations?
This property is
Weird
big
lot.
hardship.
Yeah.
There's, like I say, if we were to meet all setbacks, literally, you'd maybe be able to get a 20 by 20, garage in there, and that is it.
And again, you'll know what permits you'll need.
Yes.
That's all I got. Questions from the board?
So the southeast corner is gonna be 3 foot closer than the ordinary high water mark.
Southwest.
Southwest.
Southwest would be.
Southwest corner.
Southwest corner potentially would be, depending again, because here's the other option here would be is if I can get the home a little bit of a tilt to
Oh.
not have that,
Oh, okay.
you know, it
And you
just
still-
depends. When I get the surveyor out there, if I can make it work, I'm gonna make it work where I'm not gonna be, and that's why I put, 50 feet or greater, because I could push it back.
We did have a discussion out there about if you could bring it back 3 feet closer to the road to get you out of the ordinary high water mark.
Yeah,
No, I'm just asking,
Yeah,
have you considered that?
Yes, I could. We made this to try to get it, and again, with the surveyor, if the surveyor goes out and gets me at the exact 33, because we'd be on the road right away, I would do that in a heartbeat.
So you're willing to work with the zoning office on that?
Yes, I can push it. Yeah.
I mean, it's one less variant, part of a variance. So,
Basically, we did this, and I talked to Amy on this, is we did it to come and show you pretty much worst case scenario, but if approved, I can make this better, by surveying it.
so we can ask.
Cool.
Larry? George? John?
None.
Okay, correspondence, sir.
Okay. I
Have a
read
seat
into,
there, Scott.
I read into the last record the letter from the Department of Natural Resources. I'm gonna kind of just do a quick synopsis on this. June 12th, 2020, from Dale Resbeck, shoreline specialist, regarding the Egan property. The unique physical limitations, the applicant must demonstrate that unique physical limitations, wetlands, steep slopes, streams, rock outcroppings, or special conditions of the property exist that prevent compliance with ordinance regulations. The physical limitations must be unique to the property in question and not generally shared by other properties in the area. When determining if compliance is prevented, the whole parcel must be considered. The shape of the lot and the size of the lot should be compared with other lots on the water body in determining whether minimal relief is warranted. No harm to public interest. The applicant must demonstrate the variance will not result in harm or be contrary to public interests. Board must consider the impacts of the proposed project as well as the cumulative impacts of similar projects on the interests of the neighbors, the community, and the general public. These interests are listed in the purpose statement of the ordinance and, for the shoreland zoning, include protection of public health, safety, and welfare, maintenance of clean water, protection of fish and wildlife habitat, and preservation of natural scenic beauty. Additional impervious surfaces within the 75 setback can significantly degrade lakes unless there are means to mitigate the added runoff. Cumulative impacts to the shoreline should be considered. Unnecessary hardship. The applicant must demonstrate that if the variance is not granted, an unnecessary hardship exists. The applicant may not claim unnecessary hardship because of conditions which are self-imposed or created by a prior owner. For example, building a home in compliance and then subsequently constructing a deck without a permit, or due to a personal preference. Courts have also determined that economic or financial hardship does not justify a variance. When determining whether an unnecessary hardship exists, the board must consider the property rather than just a portion of the parcel. The department concurs with the zoning staff report and would not be opposed to a variance when adequate mitigation can be done to offset the effects of relocating structures on unique lots. And that's all I have for correspondence.
Okay, anyone in favor to speak?
I have nobody in favor to speak against or informational.
Staff comments?
Okay. As stated in the staff report, the applicant, Scott Egan, is requesting a variance to construct a 34 by 34 two-story single-family dwelling coming to within 50 feet of the ordinary high water mark of Mount Morris Lake when the average 53.5 setback is required, and to within 36 feet of the center line of the State Road 152, average 46-foot setback required in the RS20 residential single-family zone within the shoreland area of town of Mount Morris. County maintains very little information on the subject property as both the home and the lot predate county zoning. The existing home is considered a non-conforming structure as the home does not meet existing required setbacks to either the ordinary high water mark or the front yard roadway setback. At present, the home is only 23 feet from the center line of State Road 152 and 57 feet from the ordinary high water mark of Mount Morris Lake. The applicant proposes to raise the existing home and build a modest two-story, two-bedroom, one-car garage in approximately the same location. Staff has performed a couple of on-sites in the past with the previous owners to review removal of diseased and dying trees as well as placement of a new residence. Given the configuration and very small size of the parcel, a variance would undoubtedly be required. Staff has now worked very closely with Mr. Egan, who's looking to purchasing this lot and positioning any future home to minimize the extent of any variance request. As proposed, the two-story residence will be set back further from the roadway, will have only one quarter protruding out into the average ordinary high water mark setback if it goes that way, and will maintain a new sanitary system. It should also be pointed out that Mr. Egan's removing the dilapidated 30 by 16 shed located near water's edge, actually in water's edge. Scott has also mentioned his desire to work with land conservation on working to clean up the shoreline, removing invasives, and possibly look at cost sharing towards revegetation. The board visited the property at the recent onsite on Monday, June 15th, 2020, and felt the applicants have done a good job designing a structure that meets the limitations of the property. The orientation of the new structure will prevent using the road as a turnaround. They were excited to see the plans to remove the existing non-conforming boathouse, installation of a new septic system, and provide a greater setback from the roadway than what's existing. The board did inquire about the possibility of pushing the home 3.5 feet closer to the road so as to eliminate the need for a variance to the ordinary high water mark shoreline setback. They felt that 3.5 feet closer to the road was still significantly better than the situation that exists today. The applicant cites the unique shape of the property as well as a very small buildable area remaining after setbacks. Mr. Egan also indicates that the placement of a new home will improve protection of public interest, as they'll be raising a dilapidated structure that is currently located near or within state right-of-way. He is also removing a non-conforming boathouse that is in disrepair and partially in the lake. While the board will be making a recommendation on this request later in the evening, staff is recommending approval of the variance to construct a 34 by 34 two-story single-family dwelling coming to within 50 feet of the ordinary high water mark of Mount Morris and to within 36 feet of the center line of State Road 152, subject to the conditions listed in staff's report. That's all I have.
Anything else? Rebuttal? Thank you. We'll go to our third variance. Tabled from the May 21st, 2020 public hearing, Lynn Templeton, Racine, Wisconsin, has made application for a variance in accordance with sections 58, 542, sub C, sub 2, 58-823, sub C, sub 2, and 58-826, sub B of the Sheriff County zoning code to construct an approximate 50 by 28 one-story single-family dwelling on full basement with an approximate 20-foot by 7-foot attached deck, coming to within 12 feet 9 inches of the west side lot line, 15 feet required, and within 9 feet of the right-of-way of third lane, 30-foot setback required in the RS-20 residential single-family zone within the shoreland area. Location of parcel land being part of Government Lot 4, Section 33, T18N, R8E, Town of Coloma, Pleasant Lake, N253, third lane. I believe Mr. Todd has information on this variance request.
Yes, Ms. Templeton is not in attendance tonight. Ms. Templeton failed to submit all the required documentation to get on this docket. She has resubmitted information just recently. What we are asking is that we table this one more meeting and that we schedule this for the next public hearing, which is July 16th, 2020.
I agree, and I would just say that would, she doesn't appear next time, that.
Right. And we actually
the
do
third
have,
time.
we do have floor plans and elevations now, so,
Okay,
okay.
anything else? All right, we're gonna go right to our business meeting right here.